Welcome to Adventures in Life. I'm your host, Earl Beecher. Our guest is Colin Swainston. He is a practicing attorney in Newport Beach.
That's correct.
And Colin has his own firm. He's not a partner with somebody else. So Colin, explain to me why you chose to become an attorney and why you established your own firm. And then I want to find out what you specialize in.
Thanks, Earl. First of all, I appreciate this opportunity to come on, share some of my views and perspectives. I didn't realize you were going to hit me with that type of opening questions to begin with. But why I became a lawyer, I think it's a function of two things from my perspective. And I've been practicing now almost 14 years, and I think it's a combination of two things. One is your personality, and two is your background and certain talents that you see evolve in your academic career. From my perspective, it was as early as junior high and high school. First of all,
you knew you were going to be an attorney as early as junior high?
In my particular circumstance, absolutely. My father was an attorney. I have two brothers who are attorneys. From as early as I can recall, we sat around the breakfast table listening to the trial stories of my father. And when I was 16, I started working at his firm. He had a firm in Los Angeles. And I started working there, and from the time I was 14 on, I had no doubt that I would be anything but a lawyer.
What were you doing in the law office at the age of 16?
Well, I'll tell you, Earl, and to this day, I just turned 40, and I think from an economic standpoint, that was the best of my life. At 16, I was serving subpoenas and doing messenger work, and at that time, you would get $100 per subpoena, 40 cents a mile, and I'd basically go into the office, get 5 or 6 subpoenas all the way from Palm Springs to San Bernardino to Newport Beach, and you'd go to people's homes and serve them with the legal documents. That was my first real exposure to litigation.
What does it mean to serve somebody with how do you serve somebody with a subpoena? What is the actual mechanics of what occurs?
Well, first, for those who are unfamiliar with the legal jargon, in the law, there are two real branches of law. There's litigation, which I can get into if you'd like, and then also corporate law. Corporate law does not involve the rules of litigation. Litigation involves the courts and the particular rules and procedures of courts. Within litigation, to start a lawsuit, you must serve a formal court documentation through a process server, which is someone who fulfills the requirements under the particular state law. In this case, I would take court documents and go to either the business address or the residence address of the people and serve the documents. Once a person is served, that starts the
In other words, a
procedure.
16-year-old kid knocks on your door, you open the door, and he hands you a piece of paper.
And say,
you've been served.
That's correct. It could be a lawsuit. It could be notice for a deposition to go give testimony. It could be a trial subpoena. It could be a document production request, something in the litigation process. And at that time, it was a great job. And then from 16, 17, 18, I also helped with the files, and I got to be familiar with litigation and
all the legal terminology
and trials. I went a lot to courtroom, and it was there that bred my love and my interest in the courtroom.
One of the reasons I asked you to be on the show is I wanted you to sort of explain to me and our audience the various branches of law, and then you can sort of expand on the one that you picked and why. Now, you've mentioned criminal and corporate. But there's more involved in that,
yeah,
isn't there?
and that's a very broad question. The legal structure is both complicated and yet it's simplistic at the same time. Most people are familiar with if most people are like me, I like the criminal shows on TV. Hollywood has done a lot to emphasize the criminal aspect of the American jurisprudence system, and they're correct. Most of the criminal law stems from city and state and federal jurisdictions, and so you're an employee. If you want to practice criminal law on the prosecution side, in enforcing the laws, then you're an employee of the county or the city or the state or the federal government. And although if you can also have your private practice, if you're a criminal defense lawyer, you can practice both civil and criminal litigation. But those who want to prosecute people who break the law are federal or state employees, county employees, and you have to get the same credentials as a private practitioner, but then you're employed by the
Well, now,
by the
you get the
agencies.
same credentials. This is getting kind of complicated. The credential you have to get is you have to graduate from a law school and then pass the bar exam.
Correct.
I have a friend who said he never finished law school, but he passed the bar and is a practicing attorney.
In which state? In California?
Actually, yes, he's in Sacramento. He's one of the top people in the state.
Well, there are, there typically the normal procedure is you graduate with an undergraduate degree, you go to an accredited law school, you graduate usually in 3 years unless you're in a multiple joint program, and then you sit for the state exam. In California, it's a 3-day exam, and if you pass that, as well as there's a screening process on your moral turpitude and other type of issues. If you pass that, then you are licensed to practice law. If you can't get into an accredited law school, there are other routes in which you can qualify to practice law in California, one of which may be to go to an unaccredited and you take additional exams along the way.
I think he went to an accredited school, but the law school, but he didn't have I know he didn't have a bachelor's degree before he did that.
Before he did that? Well, that's a good question for the state bar qualifications. I do know this: over the last 5 to 10 years, with the evolution of the internet, the information, the access to the information is phenomenal, and most state bars have great resources of information. If anyone is interested in going to law school who hasn't graduated from undergrad or is in the middle of a law school, dropped out, you can access in California very readily any issue. The information's out there. I personally don't know. My experience and most of the colleagues I associate with, it's a normal traditional route, but
right.
I know that there are many segments of variations of that, and that's the beauty of California in particular, because we're a pretty diverse jurisdiction.
Now, there was criminal, and the prosecution people are employees of the federal, state, county, and then there's the defense in the criminal part.
Correct. And then aside from criminal, you have your basic civil structure and civil litigation structure, and within that system, there's a plethora of expertise. For example, there's family law. That's a particular expertise of family law litigation. There's bankruptcy.
Wait a minute. Family law, is that estate and trusts?
No, family law would be divorce, child custody issues,
oh, okay.
community property
that
type
aspect.
of issues, and then also adoption, things like that. I mean, we became aware of it when we adopted our child, and I got somewhat familiar with the family law code. But and I want to emphasize, Earl, I've been practicing 14 years, and I probably know 5% of all of the law in California. I mean, it's that broad, it's that deep, and it's that
That's one of the reasons I wanted you here, to show how broad it is and how many different interests that a person could have and go into that particular field in law.
Yeah, even apart from litigation, you have the whole corporate side, which involves business transactions, tax law, securities law, all of those type of issues dealing with businesses, separate and apart from litigation, which I haven't even touched. But within my own field of litigation, you have just a broad spectrum of different areas of law.
You're saying that people who go into the corporate field maybe don't get involved in litigation at all. They're just negotiating contracts and setting up businesses and helping people to issue stock and all the rest of the things that get involved?
Absolutely. For example, when I was by way of my background, for 10 years I worked in the large firms, three in particular, and one of them specialized in real estate, and the corporate department of that firm, basically covered the spectrum of all development issues, from land use, planning and zoning issues, all the way up through helping developers get permits to build, to build on the land, and then assisting them in selling off the individual lots to potential developers, and then assisting developers write the contracts to develop the land, and then also helping the developers with the subcontractors to build the actual house. So you've got, on the transaction side, all the way from getting the right to purchase the land all the way through the right to develop the land, and then the homes are built, and if they're built defectively, then that's where I come in as a litigator. And in Southern California, we're seeing a huge trend over the last 5 to 10 years in construction defect litigation. Significantly of the last 24 to 36 months, the mold issue. You've probably seen in the papers recently.
I've heard a little. We have to pause for a public service announcement, but then I'd like to get back into this because
On that
this is getting
positive
really
note.
interesting. Yes, on that positive note. So please stay with us. We'll be right back with Colin Swainston. Our guest is Colin Swainston. He is an attorney in Newport Beach, California. Colin, you had just mentioned that there was a lot of litigation in California over the issue of mold and faulty construction of homes.
Well, construction defect litigation has percolated probably the last 10 to 15 years as really the residential development in Southern California has exploded.
Has the quality of the building materials gone down as homes got more expensive? Is that what's the problem?
I don't think we have time to get into the policies and the philosophy of the evolution of construction defect litigation in California. I will say this though, the legislature has been very conscious of it, and they just passed a significant bill last year, which is an attempt to facilitate developers, private developers, and homeowners who buy these tract homes in resolving the issues before it gets to litigation. The construction defect litigation really clogged the system for a number of years, and the legislature is looking for a way to unclog it. Of late, the last 2 or 3 years, this mold issue has raised a lot of personal injury type of claims in construction defect litigation, and really caused an interest between the plaintiffs and the defense bar. By way of my practice, I do both defense and plaintiff work in construction claims. I've represented many developers and contractors, but I'm also representing homeowners against those contractors who are simply not doing what they should be doing. And
how do you determine what they should be doing?
well, there are a lot of objective criteria that you can look at. California's got a very tough licensing board. Every contractor in California has to be licensed, as we know, and their board regulates that as well as they can. I think they do a pretty good job, in my experience.
I didn't know what your specialty is exactly, but now we're off into the corporate field, but we're in construction in particular?
Yeah, well, I mean, the thing about the law and what's always intrigued me is that all of these issues overlap and intertwine. And while corporate and litigation is distinct because corporate lawyers don't know the rules and procedures of how to go into courtroom, but a lot of the underlying factual issues and practical issues overlap whether you're a corporate lawyer or what I would call a litigator, one who practices litigation.
Now, do you do both?
No, no. I think some people try to do both. My feeling is you need to really become experienced in one area. My particular emphasis is civil litigation, focusing on business disputes. I do a lot of real estate litigation, construction litigation, some securities litigation, most contract disputes, all type of business litigation. What I thought occurred to me a while ago, and it's reemerged. One thing that's always intrigued me, Earl, about litigation is I'm a fan of Western folklore. I love Louis L'Amour. Not to plug him here, but I love the themes and the characterizations and the confrontations of the Western genre. And a modern day litigator is a gunfighter. I mean, you basically learn the rules and procedures of how to take a lawsuit to the courts in California, and it doesn't matter what the underlying substance is. It can be a construction defect case, it can be a wrongful death, it can be, if it's within your ability to learn it, you learn the law and you go into the courtroom, you play by the rules, and you pitch your case, and that's always intrigued me. There's an aspect of Hollywood theater to it.
Oh, yes.
There's an aspect of academia to it, because you have to know the law, you have to research, you have to be a great communicator, both orally, and you have to know how to write. And that, one of the reasons I chose to go into the law is I recognized in school that I loved English, I loved to communicate, I had an innate ability to do so, and I think we all gravitate to that which we're successful in. And most of the colleagues and my experience are people who have likewise had a success in those areas.
All the time I was teaching, I was forcing my students to write and to communicate verbally as well as written. And I emphasize that a lot. And of course, I was in the corporate field. I was teaching finance and investments and forecasting and all of those things that are fun. But you have your own firm separate, but you were connected with several large firms. Why did you do that?
Well, my wife would probably say, "Why?" Would probably echo you. Why did I do that?
Okay.
I was trained in the firm. I felt very strongly coming out of law school I needed that background and training. And I must say, in hindsight, I had some excellent mentors, individuals, 3 or 4 specific litigators who really helped forge my path and helped me come to grips with the type of lawyer I would become. And there came a point in time when circumstance presented itself, perhaps to pursue a partnership with a firm or break off and start my own practice. And it was a tough decision for me. And basically it came down to I wanted, lawyers get a bad rap in society. You know, we charge too much.
We know an awful lot of jokes about attorneys.
You know,
I wasn't going to get into that.
Yeah, I mean, it's next to mortgage brokers and real estate agents, we're right there, with all due respect. But I wanted to try to help people, believe it or not, and at the economic structure, litigation is very cost prohibitive. Many people with great cases simply can't afford to hire a lawyer. Even they may be 100% in the right, they can't afford to hire a lawyer, and at the rates in those big firms, it's the overhead.
Well, they
is
have
very
a big
difficult.
overhead to carry.
Huge overhead, huge. $100,000, couple $100,000 per lawyer, and you have to bill a lot of time to even cover the overhead before profit's made.
Mm-hmm.
And I determined in just checking with, for the 3 or 4 years before I went on my own, I was essentially running my own cases within the firm, and I ran the feelers. I found
You
out
were almost independent at that point.
you essentially are. You report to a partner before you become a partner, but you're basically running your own cases and answering only periodically to internal supervision. And I just determined that I could cut my rates and take on some cases and do some things and still earn the living which I wanted, and also get some more practical experience. I've tried a lot more cases. I've done a lot more practically on my own.
Well, it sort of fits in with the personality of being a person who likes litigation.
It's
you sort of enjoy being into the middle of it, don't you?
You have to be. I mean, most people who know litigators or people who at least attempt to litigate, I mean, it's somewhat confrontational. I mean, I hope that I don't come off overbearing on a day-to-day basis, but you have to like confrontation. Those who know me best know that I don't shy away from a good debate, and in fact, I enjoy taking the weaker side of debates and evoking reactions from people, and I always have, much to the chagrin of my parents at times. But you have to have that personality, that personality who likes conflict and fighting for the underdog, and being able to see a fact and assess the fact and describe the fact in perhaps different ways. And that's always intrigued me about it.
I like that phrase, fighting for the underdog.
You do. And having my own practice allows me to take cases that ordinarily, if they would have come to me when I was at a firm, the retainer's too much, the hourly rate's too much, unless their case was at least 6 figures in value, a lot of firms don't take it. And so I get a lot of referrals from other lawyers who simply can't take it in their own firm, and that's worked out very nicely. And it allows me to help people who perhaps couldn't otherwise have retained a lawyer of well, I don't want to say of
a big prestigious firm.
Well, someone who's skilled as opposed to someone who's not.
Yes. Now, you talked about working with contractors and so forth. I had a thought a minute ago with the people. Who usually comes to you?
Well, I mean, I have a...
Do you get into workman's compensation or anything like that?
And let me go back. I mean, family law is a subspecialty. You really got to know your stuff before you want to venture into that. Bankruptcy, same thing. Workers' compensation, same thing. But there are areas that you can get a feel for and practice on a wide basis. But you have to be careful in what you practice. The code of ethics.
I did a previous interview with a bankruptcy attorney one time, and a lot of people are going through that now.
Yeah.
A lot of people are having problems these days, and I think with the economy improving, but the backbone jobs are disappearing. We're having the service type jobs replacing them. And it says to me, a backbone job carries 7 service type jobs. You eliminate those by shipping them overseas, and we're going to be in for no basis for these service jobs. And we're going to see a lot of folks in trouble. And I was wondering how we could help warn people, or what, as an attorney and me as a professor of finance, we could tell the public that would be helpful to them.
Well, I think my experience is just to be aware of what's going on. I mean, it's shocking to me how many clients come in after the fact, unaware of the circumstances confronting them at that particular point in time, and it hits them like a ton of bricks. And if they had just recognized months in advance and dealt with some of the obstacles, perhaps their course might have been altered and they wouldn't have faced a situation where they needed a litigation lawyer. So I think that principle applies to anyone in society. Just be aware of what's going on in your life, at your job, in your family, and if you're aware of what's around you, you can try to head off problems before they arise and become insurmountable, if you will.
They tell me it's time to pause for another public service announcement, so we will do that now. Stay with us because I've got a couple of good questions coming up for Colin Swainston. Our guest is Colin Swainston, an attorney in Newport Beach. And Colin, I wanted to ask you this. You talked about litigation a lot. Do you go to litigation with every case that comes in, or do you try to find ways of, what's the word I'm looking for?
To resolve, settle.
To settle, or even arbitrate, or whatever.
Yeah, there's a lot of different ways to resolve a dispute when it arises. The most traditional that most people would recognize is you file a lawsuit, you go all the way through the system, and you have your day in court, if you will. The Constitution gives everyone the right to a jury trial under most circumstances, and you present your case to a jury with a judge there to make sure that everyone follows the rules, and you have a verdict. As I indicated, litigation is very cost prohibitive. To go down that route is extraordinarily expensive for most people, and as a result, a number of other avenues have arisen, one of which is, you said, arbitration. There's a branch where you can hire some individuals to arbitrate your matter. It's a lot less time consuming, it's a lot less expensive, and it affords you the same opportunity to express your case.
And the arbitrator has to be an impartial person that has no interest one way or the other.
Correct. Correct. And he's trained and he's sophisticated in the area of law, but by far and away, Earl, the most prominent way to resolve matters is through a process called mediation. And once the dispute has surfaced, it's been recognized by both parties. Both parties usually get lawyers, work up the facts and the issues, and then you present it to a neutral third party who hears all of the evidence and the facts and tries to help the sides come together. And in my experience, the vast majority of all litigation cases settle informally before you reach trial or before you reach arbitration or some definitive circumstance.
Now, how much of this is settled by a judge rather than a jury?
Well, you would only have, well, that's a good question. And it would probably depend on your practice area. Most of the time, if you're doing plaintiff's work, you're going to want a jury who would sympathize more with the victims and the individuals. If you're representing corporate defendants, as a general rule, you might want to try to get it heard from the bench trial. As a general rule of thumb, everyone's entitled to a jury trial. You can waive that, and because a bench trial, a judge trial, is typically less expensive and faster. And so that's a motivator to waive a jury. However, if you're a plaintiff's lawyer and you have a good case, and for personal injury or a homeowner who's suing a contractor, you'd want to take it to a jury. If it went that far. Again, though, I would say in my experience in 14 years and probably at least 1,000 cases, 90% resolve even without an arbitrator or a judge's intervention before trial.
I see. Well, I want to thank you very much for being our guest, Colin. It's been a pleasure to have you here.
You know, it has been a pleasure. I didn't know what to expect, but it was a real privilege to talk about it.
Most of my guests don't know what to expect when they get here. I want to thank our viewing audience for joining us also, and please join us soon again for more adventures in life. And I think the law field is a real adventure.
It is an adventure. Litigation, at least, is an adventure.
It is. Thank you.
Thank you.